Hello, everybody. Welcome to the show. Let me turn myself up in the microphone so you guys can hear me. All right. We are here today. This is supposedly the last day of the actual testimony. So it's going to be exciting. You get to see what the defense brings up. It's going to be an interesting day. It's going to be an interesting day. Let me pull up the side chat so I can see what you guys are talking about. Always late part of my. It's 10:01. I've been live at 10 o'clock. I'm late. I thought it was isn't this game scheduled at 10? Maybe I made it earlier. Um, what do you think about yesterday's afternoon? I thought the cross examination was good. I thought the redirect was really good. I think the redirect was really, really good. And I thought the recross wasn't so good. So the direct examination was like, the cross examination was all right. But I think the redirect was good, and I think recross was just like wasn't really that great. But at the end of the day, it's going to come down to I think at the end of the day, yesterday was coming down to what their ME said, and I think their ME he didn't win them the case. And what I mean by that is, I don't think their ME yesterday said that Chauvin wasn't the issue. He said there were the Emmy essentially yesterday said there was a whole bunch of causes, and he wasn't sure what they were. So at this point, you got what 6 doctors that testified, 5 saying Chauvin was the cause. 1 doctor says he's not sure, he's indeterminate, right? I don't know if that gets you. I don't think that gets you on reasonable doubt. Possibly, I don't know, because the doctor didn't say. The doctor did not say. If I'm just taking it from anything else, right, from any other life experience, I got 5 doctors who say this guy was the cause, and I got 1 doctor saying I'm not sure. That's not reasonable doubt to me, right? It's not. That's not reasonable doubt. Just all right. Just maybe people don't understand. Reason just saying I have reasonable doubt. That explain to me just why you guys have reasonable doubt. If you guys can say, I don't think they've proved this, or I don't, you gotta, reasonable doubt is in your most important life, if your most important life issues with a reasonable person, you know, are you being reasonable? If an important life issue is like having a medical diagnosis, and I got 6 doctors who've given an opinion, 5 of them say this is the diagnosis, and 1 of them says I'm not sure. That's not reasonable doubt to me. But maybe you guys can explain it. Just it's not reasonable doubt in the legal sense. Maybe it, I think people are confusing reasonable doubt with any doubt. I have a doubt. Well, yeah, that's fine, but that's not reasonable doubt. Maybe, but again, you guys can convince me. Just explain to me where you're getting this from. Here it is. No, the jury will not be made aware of case law. I'm not sure how they want to do it. The case law I think we're talking about is State v. Nunn, in which the victim, the murder victim, was essentially an eggshell plaintiff. Well, people think eggshell. I like calling him an eggshell plaintiff. But the victim in that crime, it was found at court that the person would not have died, let me rephrase that. It was found at the trial court that the victim would not have died if the victim was healthy, but the victim had a heart condition. So the victim was beat to death, right? Was beat and had a heart attack. If the victim was healthy, they wouldn't have died, but they died because of the underlying assault, the underlying felony assault. So in that case, that was a felony murder case. They convicted those assailants of felony murder, even though it was proven that the victim wouldn't have died because of the assault. So that's what we're talking about. You take the victim as they are. So I don't think the jury will get that, but maybe in their jury, and sometimes in your in the jury instructions, you'll get something like that where, hey, if you believe that even if you believe that this person was a contributing factor. They'll coach it in a way to distinguish the case law, because the case law is pretty simple. He doesn't have to be the sole cause; he has to be a contributing cause, a substantial contributing cause. And just because the person is an eggshell, or just because the person has pre-existing conditions, doesn't absolve any criminal activity. It just doesn't. But that's the case law. I'm not sure how. I'm assuming they'll put it somewhere in the jury instructions, but we'll see. Let me see if there's any other questions going on. I think the prosecution's expert wins over their certainty. Yeah, I think so too in a couple of places. But it's good that when you have a whole bunch of different experts, because eventually, juries, from my experience, just break it down to the most simplest things. Does everybody, what are all these witnesses saying, essentially? Yeah, we got 5 doctors saying Chauvin was the cause. Now, if the defense witness said he wasn't the cause, then I think you get a little tension there. But he's not saying that. He's saying, I'm not sure. I'm not sure it's not a win. It's I got 5 people saying they're sure. This guy's saying he's not sure. Okay. You know what I mean? Maybe that's not making sense, but if I'm just looking at it just from that perspective. I can't figure out why EMS didn't give Narcan. I don't know either. Maybe they didn't think he was having an overdose. That's good for the people, for the prosecution. Nate, the lawyer. How's it going to play out? Chauvin is found not guilty due to politics, fear of riots. Nelson appeal. Is it IMED appeal. And gets released on bail, 12 to 18 months dismissed. I don't know if Chauvin can be found. I think Chauvin can be found not guilty. Right? It's possible. I didn't think OJ would be found not guilty. It's possible. Juries are unpredictable, but it all depends. I can only give you my perspective from what I'm seeing, and I try to just dumb everything down for myself. You got experts here, you got experts here. What's this expert saying? What's this expert saying? How was the cross on this expert, that expert? But you just don't know things that a lot of times too with these juries. Something will be said that will make such a big difference, and most people be like, most people would be surprised at what changed their mind. I don't know. I don't know how they're absorbing this information. They might have a reasonable doubt, and if they do, it's our justice system. But no matter which way it works out, I don't think there should be riots in the streets or anything, because at the end of the day, citizens, right? Normal citizens sat in a courtroom, listened to all the evidence, and came out to a decision. I accept that decision, whatever it may be, right? So in Trayvon Martin, I didn't agree with the jury, but I accept that decision, right? O.J. Simpson, I didn't agree with that jury. I accept that decision, But there are many more that I do agree with. Jacob Blake, I believe Jacob Blake didn't go to the jury, but I think Jacob Blake I think Ashley Babbitt, I think the authorities were right in that case. So, it's a case by case basis, but I think people should accept the jury system because it's the best system in the world. This is probably one of the best systems in the world. Normal people, convince them. It's the state's job to convince them that this cop is guilty, and they got to prove their case. If they don't, you don't blame the jury, you blame the prosecutors. Do you think he should be guilty of second-degree murder? From my experience in my past, if I was on the jury, he would be guilty of second-degree murder. But that's more of my own experience of being a handcuffing instructor, an aspeton instructor, in law enforcement, as a prosecutor, understanding the use of force, understanding the use of force continuum. I have a different knowledge base. So based on my knowledge base, I know my officers, if they would have done something like that, they would be charged to him and probably convicted. Especially, and here in New York, it's a little different. But in terms of just the legal understanding of the second degree charge, it's really just an assault charge, right? So is this an assault? And if this is an assault, then you got second degree murder, which is crazy, which everybody says. I say it's insane. Uncivil law says it's insane. Legal Bite says it's insane. Viva says it's insane. Barnes says it. Everybody says it just doesn't make any sense. But that's the law in Minnesota. And if that's the law, you got to prove the simple assault to prove a murder. I think they got the simple assault in spades. I'm not saying it's fair. I'm not saying it's logical. But I say if that's the law, I think second degree murder is likely. Not because I think a lot of people just don't understand. They just have to prove a simple assault. Can you keep about your comparisons with Babbitt? Yeah, I think with the Babbitt case, I think Babbitt was justified. And it's interesting. Babbitt, I think, was justified for a couple of different reasons. One, she was You got cops with guns pointed at you, saying, "Stop! Don't come here!" Blah blah. Don't come through this door. This. They break the window. You see the cops pointing guns at you. Don't come through here. You got somebody. You don't know if they're armed. You got VIPs behind you. You're the standing. You got a barrier between you and the VIPs. Then you got cops with guns, and then you have all the witnesses, right? Because you had a witness who was there with her blood on his hands, and he said all the cops were saying, "Get back, get down," and we saw they were serious. And she went to try to jump through. At that point, what other option does the cop have? I think it's justified, and and the authorities thought it was justified. So that's why I think it was justified. But and it's funny because the same arguments I had with Jacob Blake, I have with Ashley Babbitt. So it's funny, and I know it's probably going to rub people the wrong way. I think both sides use race inappropriately with these police involved shootings. Jacob Blake, for instance, he had a knife, wrestling police with a felony warrant. In what world would that not be justified, right? The guy's going into a car. He's already holding a knife. He's resisting arrest, and he reaches into a car to grab something. What world is not, I don't think any officer watching that would say it wasn't justified, right? It's obviously justified. But me saying that, it was funny because there was one person, my name, Nate Brody. Somebody thought I was white and was saying that I was saying that because I'm racist, right? I'm racist against Jacob Blake for being black. But then after I explained it, they're like, "Oh, but if he was white," and I said, "No, if he was white, I'd be saying the same exact thing, right?" And now the same thing with Ashley Babbitt, right? I think it's the exact opposite of Jacob Blake scenario, where something just so obvious that is justified. I think race and I think politics are coloring it, so we can't see it for what it is. Tragic. She shouldn't have died. Blake shouldn't have been shot. Neither should Floyd shouldn't have died. But at the end of the day, if we just look at the facts as for what they are and take the politics and race out of it, these cases become a lot more simple. But again, that's my humble opinion. Nathan Lloyd, I wholeheartedly agree on cross and redirect. It isn't quality. I think the defense expert comported himself well on cross and wasn't evasive like pro witnesses on cross. Yeah, I agree, but I think I don't know. I think the defense witnesses got beat up on cross more than the plaintiff's witness, than the prosecution's witnesses. But I don't know. But again, at the end of the day, he didn't say Chauvin wasn't the cause. He said it was inconclusive. So that's how's the jury going to take that? If I was a juror, I'm saying, well, he said he don't know, but you got 5 other doctors saying they know. That's going to mean something to me. Nate the lawyer, I have reasonable doubt because of the breathing was described when it came to my personal experience with fentanyl. It's possible, but personal experience and outside knowledge, that may be something that you can use, but I don't have that experience. The only thing I'm trying to make my decision just based on what's presented in front of me, right? This is what they presented in front of me. And if that's true, what they said, if he had this high tolerance, if he did this, I would convict on the assault. I would say this was an assault at a minimum, right? I don't think anybody would. I think 99.9% of the people, if just pulled it back and just take the names out, and just say, was this an assault? You would agree this would be an assault. And unfortunately in Minnesota, that means murder in the second degree. It just does. Damn, they said they're starting at 10:15. They haven't started yet. Nate, you missed my super chat. Oh, let me go up and see. Going up. Oh, there it is. All right. Your thoughts on having no monetary civil resources for people resisting arrest. In the right shooting, the cop does some time with no pay for payout for family. I think no for people resisting arrest. No monetary civil recourse. So in other words, I'm assuming you're saying that the people who resist arrest and the cops are hurt, they should be able to be sued. I think some states allow that. I've seen that before, where cops sue the people resisting arrest if they get hurt, right? You can sue if you know. I think some cops don't do it, but I don't see why not, right? I think that should be possible, and I do think, and I know this is going to be unpopular too, but a lot of these cases, that's what it comes down to. There's a chain of events in all of these cases, right? Let's just be honest with each other. There's a chain of events in all these cases. Jacob Blake, Ashley Babbitt, um, this one here, George Floyd, and the chain of events start with resisting arrest, right? And no one wants to say that. No one wants to say that. Even the last one I got that happened. All these chains start with someone resisting arrest, and I think a lot of these unfortunate deaths occur because people resist arrest. So when you get to the resisting arrest part, you still have the second piece of it. Was the cops reasonable in their response to the resistance? And that's where you get all this nuance. They shot one guy, this person, the knee on the neck, Ashley Bobbitt. So that's what we're talking about. We're talking about whether the response to the resistance is reasonable. And I think that's a more nuanced question than whether the person resisted. But I do think if we're talking about a logical causal chain of events, all of these cases have one thing similar. It starts with resistance. It starts with not obeying police commands, and it leads to death. So I think if you go early in the chain, you can stop it with the lack, not having them resist. But then police have to be held accountable to their actions after the resistance happens. I can't shoot somebody resisting in handcuffs, right? Unless they pull a serious threat to me, and that's what we're talking about. So yeah, so I do agree. I think maybe monetary penalties would stop people from resisting, because I think if people did stop resisting, it would save a lot of lives. Felony murder is a dumb law in general. I agree with you. Nate, the lawyer. No, they have to prove a simple unlawful assault. They have to prove an assault. And yes, an unlawful assault. Nate, the lawyer. I would acquit due to the fact that that the state hid witness such as Mr. Hall, but they didn't hide him, right? He has a right not to testify.
All right, we are on the record. Few matters to take care of regarding
and the jury won't know that. So let's listen to them. Let me turn this down. The defense is resting.
Yes. Just be able to do this.
So everybody knows what's going on. The defense is resting its case. That means the trial is over.
And you can remain seated for this. And Mr. Nelson, make sure you're close.
So they're going to ask him whether he's going to testify or not in his own defense. I'm assuming, but I don't know yet.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent. Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt. Meaning they can't say he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone.
I don't think he's going to testify. I wouldn't testify.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Smart move.
Mr. Chauvin, I'm going to ask you directly. because
Smart move. The smartest
decision
move
whether or
right
not
there.
to testify, take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And
Agree,
he
Eddie.
can give you
Agree.
advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Does anyone promise anything or threaten you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that, I'm convinced then that this is your personal decision and that you are aware of your rights. But there is a jury instruction that may be read to the jury. This, again, is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't even want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right. Anything else regarding the defense case before we proceed to talk about rebuttal?
So now we got some rebuttal
All
witnesses
right.
coming in.
We'll have you rest in front of the jury then, and we could actually take the microphone back.
Okay.
Awesome. Thank you.
Oof.
We'll have you rest in front of the jury, Mr. Nelson.
So now
With
Mr.
regard
Nelson's
to
going to rest
the
in front of
state's
the jury.
rebuttal, it's my understanding that the state is going to call a rebuttal witness. Is that correct? Okay. Whoever's going to speak to this, if we can kind of outline the topics, and if you wanted to address formally the decision regarding this newly discovered evidence.
New evidence. Oh, man. For example, like George Floyd in the case. And I don't agree with that because it'll be based on the use of force. Excessive force, no matter, even if you're resisting, it doesn't cut off excessive force. You can't use excessive force. So this I may not be too happy with, but there's new evidence. So I'm going to shut up because I want to hear this new evidence. This is new evidence. Let me shut up. Let's see what the new evidence is. Sorry. They're killing me with this new evidence. Come on, you got something. What's up with this new evidence? And I'm shocked. I'm like, we're all like clutching for pearls here. Come on, what's up with this new evidence? You're teasing us. Don't tease us like this. Tell us what's up.
Mr. Blackwell?
Good morning, Your Honor.
Good morning.
Counsel.
I was told in chambers that there was some newly discovered evidence that the state wished to present in rebuttal regarding carbon monoxide testing. Would you tell me what that was?
Yes, Your Honor. We have blood gas evidence from Hennepin County that would contain blood gas readings for the carbon monoxide content in Mr. Floyd's blood on May 25th of 2020.
All right. And when was it discovered? How was it discovered? Why
It
why
was-
was it not disclosed earlier?
It was discovered yesterday by Dr. Baker. And what had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler. And I wanted to show Your Honor exactly what it was. It was in one of the slides
Oh,
that Your Honor
shit.
can
So the
see if I
defense,
adjust the camera.
what the new evidence? How can you mess
And
up
what I'm
like
referring
this?
to,
Nelson, what are you
Judge,
guys
is the
doing over
very
there?
last reading here on the bottom.
So just so we understand what's
Where
going on,
from
he's saying the
stand, slide
defense
that Mr. Nelson
brought this new
prepared
evidence out.
was the statement and the discussion that in 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%. Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of Dr. Fowler's report at all, nor a discussion about the carboxyhemoglobin content in his blood. Now, the concept of carbon monoxide was raised in the report, but not blood gas issues related to it. It was sort of discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally. But not
Oh yeah, they should object to this. I would definitely
to
object
the
to this.
carboxyhemoglobin content in Mr. Floyd's blood. Dr. Baker heard the testimony, had not himself ever requested this, nor had the ER physicians. They explained that when somebody's brought in and blood gases are taken, there's a panel of them that are taken. The ones that get generated in the records would be the ones that the ER physicians actually request. Nobody requested carbon monoxide readings because they didn't see how that was relevant, frankly. And no one had until this testimony yesterday that was specific to the carboxyhemoglobin content of the blood and set it at 10 to 18%. Now, Judge Cahill, what everybody did have access to would be the flip side of the equation. There was information on the arterial blood gas content that showed the oxygen saturation content in Mr. Floyd's blood, and the oxygen saturation was at 98%, which meant necessarily, to the extent there was any carbon monoxide in the blood, it would be at most 2%.
Oh my God.
This was the takeaway that Dr. Tobin had yesterday from this new disclosure. And that
Oh.
and we disclosed that to counsel, that would be something that Dr. Tobin could address based on information that everybody did have available.
That's a disaster.
Dr. Baker simply then addressed the flip side of it. Was there a reading or measurement specifically on the carbon monoxide in light of this testimony from Dr. Fowler from the stand yesterday on the carboxyhemoglobin content and the slide which Mr. Nelson introduced?
Well, let me clarify one thing. When was the test?
Yeah, they're
actually
saying
run?
at most.
It was run the night of May 25th when George Floyd was brought in.
So
And you did
that's
subpoena all the records of Hennepin County Medical
We
Center.
did subpoena all the records.
And what they provided to you did not have that in it.
That's right, Your Honor.
Did Dr. Baker spontaneously call you to tell you that there might be something deep within the computer records that
Yes,
was
Your
not
Honor.
disclosed? Or did you seek him out?
it's
and
not
ask
trial
him
by
where it is?
surprise. That's what
We
the
did not
court's
seek
asking.
him out and ask anything.
If
He
you had this
heard the
earlier?
testimony, and thought that this record might exist, because he thought that, well, he was aware that there's a panel of the tests that are run by the machine, and then those that would go to the ER physicians would be the ones that they request to see the values on.
I wouldn't want to admit it either, though,
And-
because
But we
it's
did
trial by
not contact
surprise.
him. It was the other way around.
And
But-
we're talking about carboxyhemoglobin readings. Is there also anything as part of that specifically?
But it is
about
relevant, though.
Carbon monoxide
Shit.
concentrations.
Yeah, the carboxyhemoglobin reading would show the carbon monoxide concentrations, Your Honor,
And that'll
the
directly
record.
That
was
destroys
derived-
the expert.
that's
That
right,
destroys
that's
the ME's expert,
remarkable.
right? Because he's saying
But it
CO2
would
had.
return a value for the carbon monoxide content, and then would show whether or not that result is in the normal range or not.
Oh my
And
God.
that would be the reading in the readout from the test results.
All right. And so it specifically say carbon monoxide.
Well, it gives the letter symbols for it. So it would, if there's a clean copy,
What specifically does it say?
Yeah,
You
yeah.
just
Just
read it
yeah.
off
Just,
the
just
record.
give it the hell
it
it says.
says specifically in the oximetry values, it says FCO and then H lowercase b, 1.5%, and then it gives the normal range of 0 to 2.0.
So he was within normal
That's
range.
the normal range.
Wow, that just blows up the whole carbon monoxide theory.
It indicates on the record also.
He was his blood
a
was
name
he was
for
in the
Mr.
normal
Floyd.
range.
For this record, it would be last name Bronze and first name Tennessee, because at the time the tests were run, they didn't know that it was George Floyd.
I note on Dr. Fowler's report that was disclosed to the state in February that on page 15 at the top, it says, if there's a defect in the vehicle, this gas will be present, or if a person is close to the exhaust. For completeness, Mr. Floyd's blood CO level should be tested. So the state received that part of Dr. Fowler's report back in February. Is that correct?
So they
That's
should have
correct, Your
tested back then.
Anything else, Mr. Blackwell, before I turn to Mr. Nelson?
Your
Of
Honor,
course,
no.
Nelson has
All
to.
right.
He's got to oppose this. This was almost an ambush. Wow. It destroys that part of the defense because don't forget they were relying on that as one of the more
Yes, for
things.
the
so.
record, in terms of rebuttal, a couple of things I would like to address. First is this new information that was just received. I would, for the record, indicate that I received these test results at 7:53 this morning.
Yeah.
As I understand it, Dr. Fowler is on an airplane and having some difficulty reaching him at this particular moment. I have spoken with other people from the forensics panel. They're looking into these things. Nevertheless, Your Honor, the point of this is that this issue was specifically raised, as the court points out, back
Yeah,
on
in
February
February.
22nd.
You can't just
Some
come now and
20
bring
some
us
odd
this new
In
evidence.
or 40 some 60 days. I don't even know how long
Yeah.
it's been. I'm a little time deprived at this point. The point being is that the state has had more than sufficient notice. Dr.
That's true.
Fowler is opining that this could have played a role in his report. He says and suggests that for completeness, it should have been tested or should be tested. The state retained and continues to retain any blood samples. They are not within the control of the defense. The state has had ample opportunity to rebut any suggestion. As far as the information relevant to that Mr. Blackwell references in terms of the oxygen levels, the 98% oxygen levels, what Dr. Fowler testified to yesterday was how you can't rely on the oxygen levels because it's the carbon monoxide binds to the oxygen and it can give a false reading. You need this hypoxy testing, the hypoxy.
I don't know how the judge is going to
oxygen
rule.
testing. So
It's relevant,
the bottom line is,
but
is that
it's
this is
late.
information that has been within the
shit.
state's control. The
Yes.
state has had ample notice that this could have played a part of Dr. Fowler's testimony.
He's right.
It is incredibly prejudicial to the defense at
It
this
is.
point. Now, after Dr. Fowler has
Testified,
and
yeah.
left the state to bring forth evidence. Again, the jury being the trier of the fact,
Mm-hmm.
Dr. Fowler was pretty clear. He was not saying that this was the cause of death. He's simply opining that it wasn't considered by the state. And apparently it was considered to be
And
a
actually it
ridiculous
was.
concept by the state of Minnesota that they didn't think to test it.
Yes.
Since this trial has started, in addition to this new evidence, The state has had multiple conversations with a city employee about the vehicle itself.
I don't know.
They've
I'm
gone
kind of
and taken
50-50
pictures of
with
the
this.
vehicle.
I'm 50-50 with this.
All of this, they've had
I can see it going
opportunity
either
to do,
way.
But this is what they're doing
I
in
can
the
see it
middle of
because you've
trial,
already put it in
even though
front
they've known for a long
of
time that
you've already
this
put it in
information-
front of the jury.
I do have.
So you don't
I
want them
did
having bad
receive also
information.
last
It's
evening a summary
it's crazy.
of Dr. Tobin's anticipated
Now this wouldn't be Brady.
rebuttal points that three
More
of the
giggly.
4 points
Gotta look it up.
I do not see as proper rebuttal, but we can address that.
I can see an objection.
Well,
I can see sustaining the objection now.
let's address that now, as long as I'll ask the state to respond to
Sure.
something other than your carbon monoxide issue.
Yep. So last night I received a one-page memorandum referencing a conference that
Yeah,
they
the
had
jury
with
is not
Dr.
present.
Tobin.
These are
It's
motions.
date stamp 50417.
The jury's not hearing any of this. They know nothing
They
about anything we're
identify
listening to.
4 areas of potential rebuttal. The first being that Dr. Tobin will testify regarding the significance of the hypoxic changes from a physiology and clinical standpoint, including his conclusion that the anoxic seizure is not indicative of a primary cardiac event based on the timeline of significant events. I believe that Dr. Tobin has already
they explained it, so
testified as
we'll
to
see. Well, hold on.
the-
Let's see.
his
But they, yeah,
opinion of the
they're not supposed to.
significance
It's
of
not trial by
the,
ambush.
anoxic seizure. I mean, that formed.
I think I would sustain the objection,
how he
but I just don't know.
that. Now, the fact that there is a differing opinion that it's a cardiac event instead of a hypoxic event that's the nature. Again, state has had ample notice. It's not rebutting. It's just simply reintroducing what Dr. Tobin has already testified to extensively.
Well,
That's a rebuttal. That's what a
my
rebuttal
recollection of
rebuttal
Dr.
witness is,
Fowler's
though.
testimony is that
Yeah.
he agreed that it's a hypoxic reaction.
Yeah.
But it's just the mechanism. I think we're talking about the
mechanism of the
due to
hypoxic
positional
reaction, yeah.
asphyxia
Correct,
versus
Your Honor, correct.
versus cardiac arrhythmia. But I think they all agreed that it was a myoclonic seizure as a reaction to hypoxia.
Agreed, Your Honor. But the mechanism being the point of what Dr. Tobin has
Right.
already extensively testified to.
Right.
Right.
Yeah,
the fact
I agree with
Dr.
that, too.
Fowler had a different opinion. This is not proper rebuttal because it's
He's right.
already been testified to at length.
Yeah.
What
I
the
think I would
mechanism
deny
of
it,
the
too.
seizure has already been opined by Dr. Tobin.
Yeah. You don't rebut
The
something.
second area
just say it again.
that
That's
Dr.
it. That's what
Tobin
he's saying.
has indicated is he said Dr. Tobin will testify regarding the scientific research supportive of his analysis that showed how the hypopharynx can be narrowed.
That's a point of
Again,
contention.
I believe that he has already extensively testified to his position as to the narrowing of the hypopharynx. Whatever this additional research is, I have been provided with a single journal article relevant to the treatment of COVID patients that was provided to me last night as well.
Yeah,
if
it's
it's
providing
limited
everything
to
last
that
night. This
single
is
article. I guess that could be construed to be
yeah. You got to let
additional
that in.
evidence,
Yeah.
but again, Dr. Tobin extensively testified as to his view of the narrowing of the hypopharynx.
All right. So let
The
me let him
third
finish it, then I'll explain
area
what's going on.
is what is written as follows. Dr. Tobin has reviewed and will testify as to his analysis of the 2 studies of Dr. Fowler cited regarding outdoor exposure to carbon monoxide. Dr. Fowler testified that Mr. Floyd could have had a level of 10 to 18% carboxyhemoglobin as reflected in the slides disclosed.
But we know
on
that's not
413,
true, though. Now
and that in his opinion, this level could have contributed to Mr. Floyd's cardiac
that's what he said. So
death.
we know that's not true
Dr. Tobin
because
will
of the
rebut
test.
this analysis and provide his opinion that based on lab tests done at the emergency department, Dr. Fowler's analysis does not hold. So
That's hard. That's a
this
rebuttal.
Email
That's
being
hard.
Sent at 4:53 p.m. last night, or approximately 5 o'clock.
He's got to
last
argue
night,
time with this one. He can't argue the rebuttal.
suggests that Dr. Tobin may have seen these test results or the test results done at the emergency. There's no
John O'Brien.
indication is
Some
it
of this is
new
legit.
test
Some of it is
results or
BS.
is
Some of
it
it's
some
legit,
other
though.
test
I agree,
result?
though. I would be annoyed if I was a judge.
Nevertheless,
Come on, it's the last second show.
nevertheless, it's our position that these new test results should not go in front of the jury, first and foremost. And second, if they were, I would be moving for a mistrial based on this, because again, the state has had ample notice. Finally, Your Honor, the fourth
Let me check my
paragraph reads, in his report regarding the size of Mr. Floyd's heart, Dr. Fowler cited 2 studies, the Molina and DeMaio study and the Northwestern study from 2021. However, Dr. Fowler did not cite the Mayo study that he referenced in direct examination, and he did not offer the opinion that Mr. Floyd had an enlarged heart. Dr. Tobin will clarify the facts underlying these studies and their application to Mr. Floyd. Again, this is the very nature of our system, right? There's an opinion and there's a counter opinion that we both, Dr. Tobin has already cited this study. He has talked about this study. He acknowledged the existence of the other studies. So this is not proper rebuttal because it's already been testified to. They're trying to recreate and get Dr. Tobin in front of the jury again to talk about things he's already talked about. The CO2, fair enough, right? To some limited extent based upon, Dr. Fowler's testimony.
So he's given up on the CO2 to a limited extent.
Mr. Blackwell, let's talk about those other, aside from the lab tests, those 4 points that the state is seeking to present rebuttal.
Test. All right, so my mic should be blowing you guys out. But you guys can still.
Obviously, Your Honor, we wouldn't be having any of these discussions this morning had there not been new opinions from Dr. Fowler raised from the stand. And one of those new opinions, and one which I think I was objecting to at the time, was his discussion of the Mayo study. This had to do with the whole issue of the enlarged heart, the cardiomegaly. And he had disclosed to us his reliance on Molina and DeMaio, and also the Northwestern study that was in his report. And as Your Honor well knows, the whole point of having reports and disclosures for both sides is so that both sides have notice for what's going to be testified to on the stand. So he testified about the Mayo study anyway. He expressed his opinions about the Mayo study. It was a free kick at the goal because we didn't know that he was going there.
And what study again? Could you spell that one? Because I'm mixing up DeMaio and
Yeah, the Mayo study is M-A-Y-O. It's as though it should be pronounced Mayo.
Okay.
And what Dr. Tobin would talk about would be
it'd be unfair
that
if you
particular
just
study,
spring it on them at last minute.
and the fact that in the opinions that Dr. Fowler had presented in his
I
report,
caught this one before.
he didn't
but yeah,
offer
I
the
agree with
opinion
this.
that Mr. Floyd had an enlarged heart.
Bring things late.
He
2
offered
days
it from
before
the
it,
stand.
right
He
after
didn't
the
offer it
defense
in his
closes.
report.
It's tough.
And had we known at the time from
Put
the
the judge in a tough
disclosures
spot.
that
I would
that's
move
what
for
he was
mistrial.
going to testify to, then we would have addressed it during his
I'm with you,
testimony
John.
during his direct when he was here before.
Well,
But
let me ask you. So, what specifically do you want Dr. Tobin to testify to regarding an enlarged heart?
he will simply testify that if you then look at the overall studies, including the Mayo study that we've been talking about, that Mr. Floyd's heart weight does not fall within a range that
He's
is
not a public
abnormal.
defender.
So he'll talk about the broader sort of pool of studies in the framework of discussing the
Yes,
Mayo study
exactly.
that we had
That's why
learned
the judge
about,
is saying you should have brought it in earlier.
at least that
you knew what he
Dr.
was gonna
Fowler was
say.
going to rely
Could
on
have
in his
rebutted it
testimony.
on direct.
I guess one question I
Last
have
second.
is, he's the pulmonologist. He's not the cardiologist. Are you recalling your cardiologist to talk about the enlarged heart and give an opinion about an enlarged heart?
No, Your Honor, just the pulmonologist.
Okay.
And obviously, it's a cardiopulmonary system, and they both kind of operate kind of hand in glove. So we felt, frankly, in the interest and respect in Your Honor's admonition, that we try to be focused substantively and temporally to simply call one person to talk about this and not multiple ones.
Okay. What about the other?
On the
Chauvin
issue
a
of
very
the
good doctor,
hypoxia,
Very good witness.
for the first time from the stand,
No, you're looking
we
next
heard
week, Tuesday,
from Dr.
after
Fowler
Tuesday.
that an anoxic seizure was evidence of a primary cardiac event. Your Honor is right in what Your Honor had understood, that both sides do understand kind of what happens when you have an hypoxia event and how one passes away. What we had not heard was Dr. Fowler attributing it to a primary cardiac event. That was not in this report.
No, we didn't leave
And it was
we didn't leave
disclosed
our,
for the first time
our-
from the stand.
I know.
And as well as relates to the hypopharynx, that was crystal clear from the stand that Dr. Fowler said.
They could, but it's
Having
already,
heard
the
Dr.
door's already
Tobin
open. It's already in
testify,
front of the jury.
I went out to canvas
So
the literature
they
and I
do
found
have-
nothing
they
there
can rebut
supportive of his theories.
But they can't rebut. They
somebody
can't
who,
hold evidence and then
has
rebut it and
studied,
say, "Oh, we got this."
the
No,
science
you
of
have to,
breathing
you
for
know,
46
you have to,
years.
You got to turn it over.
So what Dr. Fowler would testify
trial
there
by
is what is the nature of the research in that respect, in
So
direct
I don't know what
response
their
to the
entity is. Just want to be clear. I don't know
the
what
new
their-
statement from Dr. Fowler from the stand.
Let's talk about the opinion regarding the carbon monoxide
Maybe
effect.
I know where we were
and
at. It wasn't.
Dr. Tobin's opinion, which would appear to be within the scope of his expertise as a pulmonologist. But is it going to be solely talking about the lab tests?
It is solely talking about the carbon monoxide content of his blood, Your Honor. And I don't want to try to answer the court's question as clearly as I can.
No, go ahead.
It isn't just talking about the test results. The test results are subsumed in it. But the bottom line of what he's talking about is what is the evidence as to whether or not the carboxyhemoglobin content, the carbon monoxide content of his blood could have been in the range of up to 15%. And he's saying that based upon the medical evidence available, that was available to everybody, looking purely at the oxygen.
What was available to everybody?
The oxygen saturation content of his blood.
Okay.
And contrary to counsel's comment on the
Yeah,
science,
but then you also have to think about the flip side.
the
of
way
this,
that the
John.
oxygen
Is
saturation
it fair
works,
to let the jury go
we
and
have
deliberate
hemoglobin, so either
with
the oxygen is gonna
information that
combine
you now know
with
is
the
wrong
hemoglobin
or
or carbon
deceptive?
monoxide will.
That's you know
And if carbon monoxide has bound
that's what the judge has to
to it, then
to
you
weigh.
can't have an oxygen
The judge has to
saturation
weigh.
of
No,
98%.
I understood the
It's
testimony.
crazy.
So that is what he would speak to. The test results
Thanks,
are merely
Russell.
corroborative of that, because the test results show a specific testing for carbon monoxide itself, and it isn't simply derived from looking at the oxygen saturation content, which is at 98%, and
Yeah.
therefore the most carbon
think you got the
monoxide could have
manslaughter.
been is 2%.
Felony assault is felony
so it
murder,
is
though.
addressing the same issue
That's
from the
tough.
two
If you
different
say felony
perspectives.
assault, you got felony murder. That's 40
Oxygen
years.
saturation versus actual testing and the test
But I think your
results of the
manslaughter's
carbon
right.
monoxide itself.
Well, I agree with you that if the tests had been disclosed earlier before Dr. Fowler testified, there'd be no problem with putting that in as rebuttal.
So yeah,
Probably there would have been no need because Dr. Fowler would have been advised of the results,
and then he could have
and,
made the thing. Yeah.
testified accordingly. So there would have been no need for rebuttal. So, but other than that, so are those the four topics though? Did counsel set those out pretty good?
Oof.
Yes, Your Honor.
All right, thank you. All right. First of all, in dealing with these lab test results,
What do you guys think?
I
I think
find
it's a
that
no.
Dr.
it's a
Fowler's
no.
report gave sufficient notice to the state that carbon monoxide,
I called
the
it.
carbon monoxide
I
that
thought it was a no.
potentially was in George
I
Floyd's
wouldn't.
blood
I wouldn't let him testify
could
to
have
it either.
affected cause of death.
Yeah. Now
I
you
read
can't just surprise us with it.
page 15 of his report, which I don't have at my fingertips at this point, that basically they said it, Dr. Fowler came right out and said it should be tested.
Yes.
That
In-
gave
in
the state
February.
notice with
Mhm.
sufficient time in February to either test the samples that are still there
Yep.
or to dig a little deeper.
It's
It's
completely
just by,
unfair now.
Serendipity that Dr. Baker
They had the report.
calls the state and says, "Oh,
I
by
said
the
it.
way,
I said
does
it was
exist."
going to be exchanged.
should be
I
in
said
there.
it should be sustained.
It
right?
seems to me very odd.
So-
I'm not claiming any bad faith on the state's part, but it seems
but it's
odd
not
that
fair.
Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper.
Yeah, he's going to have. Yeah.
Their
This objection is
response to the subpoena was
No matter
probably
who you feel for,
insufficient in
this
and
is
of
the
itself.
right objection.
And they should check their standard operating procedures. So
I
that
wouldn't
in
let it in.
the event this happens again, that they will supply all the information they have.
But you can't
But in
penalize
any
the defense
case,
by that. Come on.
Uh,
Sustain the
The
objection.
defense gave notice that this was going to be an issue and specifically talked about testing the sample.
Yeah,
The
you
state
can't let
has
this happen.
sufficient time to investigate and disclose to, even if it's just because Dr. Baker called the state and said, we can actually find this at 8 o'clock this morning, when the state is, or the defense expert is done testifying, has left the state.
It's
It's
unfair.
untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not
Yeah.
due to bad faith. But the late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Tobin will not be allowed to testify as to those lab results. If
Yes.
there's anything he wished to add
Agreed.
about carbon monoxide as far as environmental factors, but
Mhm.
if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial.
Mistrial. You can't say
Pure
it.
and
Yeah.
simple.
Yeah.
This late disclosure is
It's just too much. It's
not the
it's
way
not
we should
it's
be
not fair.
operating here.
Yeah, it's just not fair.
In that case,
I think Chauvin is
Dr.
guilty,
Tobin
but
may
that's not fair.
testify
You can't let that in.
as to carbon monoxide if he sticks to the environmental factors. And
Yeah.
as a pulmonologist, looking at the videos, for example, and seeing
Yeah.
Mr. Floyd's location and not knowing whether the vehicle is even on or not, which the state brought out in cross-examination.
Which is good. Yeah.
All those factors he can talk about environmentally.
If he says test,
and
he says
what
the word test, we
likelihood
got a
is that it would
mistrial.
affect his carbon monoxide concentration in Mr. Floyd's blood, that's fine. But nothing about these lab test results that were just.
But now remember, the
disclosed
lab test
8
results
a.m. this
say
morning
that
after the defense expert,
carbon monoxide was normal. They can't say that
is
because it was
done.
too late. So
With
the
regard
judge
to
is
the
right. I agree with the judge.
DeMaio, I will allow.
Got to allow that one. Yeah.
I have a little concern that we're having a pulmonologist opine whether it's an enlarged heart or not. But given his background, which, as I think Mr. Blackwell appropriately stated, is a cardiopulmonary system, it is a system, and I think he has some expertise in the function of the heart and its relation to the lungs.
Pulmonary system, yeah.
And so I think it is appropriate that he be allowed to opine whether or not the heart was enlarged or not.
If it's their fault, they don't get a second bite of the apple.
Responding to those studies.
So jeopardy may
as
be
the
attached.
scientific research, the defense did bring up as a new issue whether or not narrowing of the hypopharynx is supported in literature. And Dr. Fowler said he did a check and he didn't find anything. I think it is permissible that Dr. Tobin be allowed to come and say, since Dr. Fowler's testimony, he has done his own search or he relied on this.
That's
and
proper
there is
rebuttal.
Literature, and he can talk about the literature in a summary fashion.
All right.
With regard to the hypoxic seizure, it was pretty clear from Dr. Tobin's testimony that he had an opinion that there were movements of George Floyd's legs, that those were myoclonic or anoxic seizures due to the lack of oxygen. Dr. Fowler did not really dispute that. He also indicated that it was a lack of oxygen to the brain that causes such seizures. The only difference between the two was the mechanism. Did the lack of oxygen, was that caused by positional asphyxia versus cardiac arrhythmia? And as I recall, Dr. Tobin excluded cardiac arrhythmia or a cardiac event as the cause of the lack of oxygen. Since he has excluded a cardiac event as the cause of the lack of oxygen, that evidence is already in the record.
Here's rebutted.
I don't have to remind both sides that the purpose of rebuttal evidence is not to restate what has already been testified to.
Correct.
It's to bring up new evidence to rebut something that came up in the other side's case. Accordingly, as to the hypoxic seizure, that's not going to be allowed. The scientific research supporting hypopharynx narrowing will be allowed. The lab tests are not allowed to be discussed, but Dr. Tobin can talk about carbon monoxide and the likelihood of a high carbon monoxide reading based on environmental factors if he wishes, because that was gone into a great extent. And finally, the reports, and he may opine whether, in his opinion, George Floyd's heart was enlarged or not.
All right.
Do we have pretty much the ground rules set?
Just one question for clarification on the carbon monoxide. There were test results that existed before the ones that are at issue from last night / this morning. What Dr. Tobin, these are ones that relate to the oxygen saturation. So that was known before last night. And so I haven't talked to Dr. Tobin this morning about what he's going to say or when. I might ask the court for a few minutes before we start. But what he was able to come to last night without saying anything at all related to these test results at issue was we had the results already, both sides do, on the oxygen saturation in his blood from May 25th, 2020.
Well,
It's-
let me
Okay.
ask you this. Is his opinion going to be that when the oxygen saturation levels are this
98%.
high, that precludes high CO?
Correct.
because
That's what he's going
a
to say.
high carbon monoxide reading would depress the
CO reading. I mean,
saturated
the
oxygen.
oxygen reading.
That's
yeah.
correct. They are would be inversely related. So a high oxygen saturation.
would
Low
indicate
CO
a
relating.
low
Yes.
carbon monoxide.
So in other words, you're getting the test results in
Nelson?
without getting the test results in.
As I understood Dr. Fowler's testimony, at lower levels of carbon monoxide, because the pulse oximeter it's not going to differentiate based on the color of the blood between oxygen and carbon monoxide.
That's you got to get an expert on.
This is the
understand
bright
that.
cherry red testimony.
Correct.
I think that's appropriate cross, but I think if that is in fact Dr. Tobin's opinion,
He's
that
got to let that in.
these,
Yeah.
Oxygen saturation readings, which have been disclosed
Inverse
earlier,
relationship. Yeah.
would indicate a low carbon monoxide reading because they are inversely proportional.
Woo. So you get it
And
in.
It's appropriate, however, to say those readings are based on pulse ox, color of the blood, color of the fingernail, and the bright cherry red, essentially confronting him with that testimony. I think is appropriate cross, but it does not preclude the state from recalling Dr. Tobin for that purpose.
Wow.
That's
All
the
right.
clarification, Your Honor.
So
All
we
right.
got a lot going
Yeah,
on
that
here.
would be permitted.
All right.
All right. Anything else before? And you want a few minutes to talk to Dr. Tobin?
Tobin's coming back. We get to see the
Why don't
star
we start
witness.
up at 10 o'clock. I assume he's close.
3
by.
minutes, huh? The judge is
You
like,
can do it quickly,
you
Mr.
got
Blackwell.
2 minutes. Like, come on, it's 10 o'clock. Give
I,
me a
I
couple
think
of
since
minutes.
the
Yeah.
defense is going to rest and you'll proceed directly to Dr. Tobin, are we calling anybody else?
No one else, Your Honor. And if we could have to 10:15.
10:15 it is. All
Thank
right,
you, Your Honor.
10:15 we'll
All right.
reconvene. Thank you.
So let me just, all right. So we got 15 minutes, but just so we understand what happened, right? So the states last night after the defense witness started talking about carbon monoxide, they went, the ME gets on the phone. And he's like, hey, listen, guess what I just found? I just found these wonderful tests, and the test shows that his CO levels were normal. So they come into court today and say, hey, we have these tests. It says CO's normal, right? We got the defense expert. But the defense was like, well, hold on here. We told you we were going to bring this up in February. You had these test results back in February. You're supposed to turn over everything to us as the defense. Remember, you're supposed to turn over all your evidence so we can evaluate it and we don't, not surprised. You held this to today. You had this all this time. And now, after we've closed our case and our expert is on a plane, you want to say, well, here's the report, right? That shows that he's inaccurate. That's not right. You can't do that. And the judge appropriately said, no, you cannot just surprise us with this BS, right? Last second, because it's unfair to them when you knew that they were going to say this, and you can't have trial by surprise. You have to give them your evidence, right? It just is not, and it's prejudicial to their defense. Fine. So it's out, but it's out. It's so bad that it's out that even if they bring up those new test results, Chauvin will get a mistrial and likely will not be able to be reprosecuted. So they can't bring up those test results at all. Second, but the state had a second way to get those test results in. So they're saying, well, we can also bring this result in based on blood saturation levels, right? So in other words, your 100% saturation. If your blood is 98% saturated with oxygen, then there's only 2% left to be carbon monoxide. So that's what they're saying. They're saying, well, even if we have this other test that says we have 98%, he's 98% oxygen, only 2% carbon, so the max carbon monoxide can only be 2%, which would still be in that normal level. So they can use that because the defense had those test results for that, but they didn't have the test results that they just all of a sudden found last night that they had for 2 months ago. That's wrong. So that's where we're going, and there's some other things that he's going to rebut on cross. So that's what we're going into. The judge is amazing. That was the right ruling. I would have done exactly the same thing. You can't just bring something last minute and just say, hey, guess what we found? Especially when you had it for almost 2 months now. That's bullshit. That's wrong. I don't care what you think. If you think Chauvin is guilty or innocent, that's just wrong. That's just not fair. That's just not fair. So the judge made the right decision, and we are going to move forward. So new evidence, and let's just be clear. We all know now. The jury will not know, but we all know his carbon monoxide levels were within normal ranges. So the whole car thing had actually played no role. But the jury will not know that. The jury will not know that test result because the state hid it. Well, not hid it. They, didn't turn it over for the past 60 days or 2 months to the defense and tried to hit them with it last minute. So that's why it will not be coming in. It's the state's fault. The fact that the prosecutor had given the defense information either the night before or the day before, not all to be grounds for mistrial or appeal. No, because there's different. You can turn over things the night before, and there's certain things you have to turn over earlier. So no, it's not grounds for. No, it's not grounds for appeal, mistrial. And it depends on what type of evidence, when you get the evidence. Like if this test result they found last night, different. This test result was found February. Problem. I'm not February, like earlier on. I think whenever it was found. But it wasn't found. It was. Oh, we have this test result last night, but it was. Oh, let's turn it over to the defense last night. So that's I don't care what side you're on. That's wrong. That's wrong, and rightfully so. It should be thrown out. It should be suppressed. So we'll see. Get your coffee because this is going to be explosive. You got Tobin coming back. He's gonna try to lay waste to the other ME who's on the plane who can't rebut. And then today we'll see. So I'm assuming this is going to go maybe till lunch. Then the cross is going to be good because the cross examination is going to say, well, we really don't know what that level is, right? Because the test that they're using is not really conclusive. So they'll go with that, and it'll be interesting. So hold on. Somebody said my volume. I thought my volume was all right. Thanks for the $5. Thanks for the $5. I appreciate it. So don't go anywhere. This is going to be interesting. This is going to be explosive. We're going to be watching this. You've been watching the Derek Chauvin trial. My name is Nate the Lawyer. Coffee cup is empty. I got to use the bathroom. This starts at 10:15. Well, 10:15 their time, 11:15 my time. We have about 12 minutes, and we're going to get into it. Let me see. And the questions on cross. You already know what he's going to be asking the pulmonologist, right? The judge already was asking. He's not a cardiologist, right? So on cross for what he's going to be saying. You're not a cardiologist. Listen, you're talking about enlarged hearts. Just to be clear, you're not a cardiologist, right, Dr. So we know that question is coming because the judge even said it, right? So we know that question is coming, but we'll see what's going to happen we'll see what's going to happen later. Read the conclusion. Well, let me go make my coffee and go to the bathroom. Hold tight. We got a little break here. Go use the bathroom. Go get something. Go get comfortable because we're gonna have a little bit of time here. So I will be right back. All right, people. Welcome back to the show. Oof, we got 3 minutes before we start again with the rebuttal witnesses. So, just a quick recap for all of you people who haven't been watching from the beginning. Let me just make sure this is very clear what's going on. So, earlier today, Derek Chauvin, is it Chauvin or Chauvin? I'm going to call him Chauvin, but anyway, Derek Chauvin came forward and said he is not testifying, right? He is not going to testify. The reason why he's not going to testify because he's got a Fifth Amendment right not to. Him and his lawyer, they said they're arguing about it, but he is not testifying. So Derek Chauvin is not testifying. He's got a Fifth Amendment right, and they're going to read something to the jury to let them know that, hey, even though he's not testifying, you can't use that against him, right? Because he has a right under our Constitution not to testify. That's number one. Then we had rebuttal witnesses. So the rebuttal witnesses is really just Dr. Chauvin. Now this is just me thinking about what's happening. I'm thinking he saw the testimony yesterday and was upset. Was like, "Yo, we're going to destroy that guy tomorrow." So Chauvin coming back, but we had some surprise new evidence, quote unquote, new evidence. So the new evidence is that the defense expert testified that carbon monoxide may have been a cause of some of the low oxygen. And that since the test wasn't done, it's kind of like it's there. It could be, but who really knows? They should have done the test. So the state didn't turn over the fact that they actually had done the test, right? They did the test months ago. I think around when Floyd died. So they did do the test, they did have the results, but they never turned over those test results to the defense. So the ME calls the state up last night and says, "Hey, I watched the testimony. We did have those test results. We found them. They were just, and here they are." So they turned them over to the defense. The defense was like, "Well, hold on. You knew months ago about these test results. And on top of that, we told you, we gave a report saying what our expert was going to say. Our expert was going to say this carbon monoxide thing. And you had the test results. That doesn't give him enough information. So he can't look at it and say, he can't give an informed opinion if you don't give him all the information. So he said something. You've given him, you said the test results weren't there. He's now made an opinion. You come out and say, well, we do have the test results. And now it's making him seem like he's a liar instead of giving him the full information, letting him come to an informed opinion. And it's unfair that the jury is now going to hear this, and the defense doesn't really have any time to rebut it because their expert is on the plane going to wherever. So the judge didn't allow that in, and the judge even made mention that if that does come in any way, the prosecution brings it in, for instance, you will have a mistrial. The defense brings it in, they open the door, the prosecution, and it'll be a mistrial. So that's where it is. So Chauvin is now going to testify. He's going to try to dispel some of the stuff that the ME from the defense side has said. I mean, that's what we're looking at today. One of the things about being the enlarged heart. So even the judge made mention that, well, hold on. Chauvin is not a heart doctor, right? He's not a cardiologist. He's a pulmonologist. So that is going to be some of the issues that are brought up on cross, and the fact that the test result that they're going to be relying on isn't as accurate as the test result that's not allowed to come in. So that's what we're looking at today. So we'll see how the rebuttal witnesses work out. I think the judge made the absolute right decision. You can't just surprise somebody with evidence that you've already had and just, hey, guess what? We have this evidence that we didn't turn over, so to make your expert look like a fool. No, that just doesn't work that way. That's just not fair. So that's what happened this morning. And we are now waiting for, the judge to come back. The defense has closed, so there should be no more defense unless they have some rebuttal witnesses, which I don't think they have. I'm assuming we're not going, today is Thursday, so I'm assuming tomorrow, which is Friday, we're not going to have any trial. It's just going to go into the weekend. Monday we should have, Monday we should have closing arguments, and then it should go to the jury either Monday or Tuesday. Also, just so we can all be sure, the test result for we're gonna make sure the test results that they are allowed to use are ones that have already been turned over to the defense, and it's just saying that there's an inverse relationship between oxygen saturation and carbon monoxide saturation. So the oxygen saturation was like 98%. What the defense but that test that they're going to use and that Tubin's going to use to show that the CO2 levels were negligible, they're average. That test is just not as accurate as the other test. So they're able to use the inaccurate test to show that the CO2 levels were accurate, were within normal ranges, but they're not able to use the more accurate test because they had the information and held it to the last minute. So that's where we're at now. I hope I explained that well. I know there's a lot of information, but I was trying to, get all that into a nutshell. Dave Rucker says, change the name of your channel to Nate the Beast, best legal channel. Maybe future play-by-play of trials. Maybe. This was hard though. This is hard. YouTube threatening me up, and closing down the live stream on you looking at a public feed. This is crazy. It's like, what the hell's going on? Here he is. So, but thank you for the $5. I appreciate you liking this stuff. Nate the lawyer, you spoke fast. If the defense brings up, does that mean the prosecution is safe to talk about it? Yes, it's called opening the door. The defense, if the defense brings it up, then the prosecution can definitely open it up. So, but it'll be stupid for the defense to bring it up. Then we're talking about ineffective assistance of counsel. That's what we'd be talking about at that point in time. Nate the lawyer, can the judge still issue a directed verdict for acquittal? Yes, but I at this point I don't see how you can get it. I don't see how you get it right. They missed that. Nate even said, yeah, oh no, it's messed up. Oh no, it's horrible. It's you guys don't know how messed up it is. Just imagine, right? You have an expert, they give you all this information, you send it all to the expert, and they leave out one piece, and then your expert gives a report and says, hey, you guys didn't check carbon monoxide. That could be a cause that nobody thought. And then your expert goes on, gives all this testimony. Come to find out, they had that test result for like months and didn't turn it over. Yeah, it's definitely messed up. So it is what it is. All right, here we go.
All right. Good morning, everyone. Sorry for the delay.
Oh no, my right eye.
Mr. Nelson.
Hear me?
Your Honor, at this time, the defense rests.
Thank you. Mr. Blackwell, does the state have rebuttal?
The jury is present at this time.
You may
The jury is
proceed.
present at this time. This is rebuttal.
Good morning, Your Honor, counsel, ladies and gentlemen. The state will recall to the stand Dr. Martin Tobin.
Here we go. The star witness. I'm going to call it Tobin the star witness because everybody loves him.
In just one moment, Your Honor.
Not a problem.
He's probably taking a piss.
Dr. Tobin, since we are recalling you, I'm going to swear you in again. Yep. Raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and nothing but the truth? I do. See it again. And just for the record, if you could restate your name and if you feel comfortable, take the mask off.
My name is Martin Tobin.
Mr. Blackwell.
Thank you, Your Honor. Good morning, Dr. Tobin.
Mr. Blackwell?
Thank you for rejoining us. Got just a few follow-up questions to ask you in rebuttal. But first, just so you're introduced to the jury, you're a pulmonologist.
Correct. Lung specialist. Yeah.
A critical care physician.
Yeah. Intensive care doctor.
And you studied the physiology of breathing for 46 years.
Correct. Yeah.
I want to first ask you about the issue of Mr. Floyd's potential exposure to carbon monoxide.
Yes.
Were you able to hear testimony regarding this yesterday?
Yes, I was.
Were you able to see this particular slide and the highlighted statement at the bottom, in 7 minutes, Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%.
Correct. Yeah, I saw that.
Would you first just tell us right off the bat, do you agree with that proposition that's highlighted there?
No, I do not.
Now, would you tell us what carboxyhemoglobin is?
Yeah, carboxyhemoglobin is when the carbon monoxide combines with the protein in a blood that's called the hemoglobin. And so it's the combination of the carbon monoxide and that protein in the blood.
And why is carboxyhemoglobin, again, important?
It's important because when the carbon monoxide binds to the hemoglobin, it displaces the oxygen off the hemoglobin. So you need the oxygen on the hemoglobin. You don't want the carboxy, and it takes it over.
Then do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18% is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on the arterial blood gas that was obtained when Mr. Floyd was in Hennepin County.
What? That's a mistrial. What the hell just happened? Didn't he just mistrial it? Did they just mistrial? That's a mistrial. Didn't he? What? Did he just mistrial it? Oh shit. I think he just mistrialed it. He just mistrialed it. Did he just mistrial it? Don't tell me this guy just mistrialed it on the first question. What the hell? This is insane. He just mistrialed it on the first question. He said, don't bring up the test. Oh my God. Oh my God. Maybe he's going to say it's we was talking about the other test because of the test from last night. Didn't he tell him, no, you can't speak? What? Oh my God. What just happened? Did he just mistrial it? I think he just mistrialed it. What the? Did he just mistrial it? Am I crazy? He just mistrialed it, no?
I think the objection should be sustained, but just rephrase.
Thank you, Your Honor.
Okay, all right. It didn't get bad
Dr.
enough.
Chauvin, as you prepare to tell us why these results, in your opinion, are not reliable, could you please help the jury to understand something about oxygen saturation testing in the blood?
So if you have,
was it
like
that
we
bad?
saw in Mr. Floyd, when he went to Hennepin County, he had an arterial blood gas obtained. So that's sticking a needle into the artery at the wrist, and you take out the blood.
Okay.
And then on the blood gas measurements, you measure a number of different
I think
items
that's
on
ready
that,
for a
like
truck-
the pressure of
Bill.
oxygen in the blood, the pressure of carbon
shit.
dioxide, the amount of acid in the blood called the pH. And you get all these different measurements, and you also get the oxygen saturation. And that is
Yeah, the judge saved it. The judge
how
saved it.
much of the hemoglobin, the protein in the blood that carries the oxygen, how much of that
See how
hemoglobin
long
is
that was, right?
saturated with oxygen. And we know in Mr. Floyd that it was 98% saturated.
So 98% saturated with oxygen.
With oxygen when they measured it in
Oof.
Hennepin County.
Not
So
a
that was
mistrial, but very
9/16,
close. That was as close as you're going to get to a
the
mistrial.
time frame.
Wow.
So if we know that there's an oxygen saturation of 98%,
That's insane.
does that tell us anything whatsoever
Yes,
about
it
what?
does. I'm sorry, I interrupt. I apologize.
Does that tell us anything whatsoever about what the carbon monoxide content could have been at a maximum?
Yes, it does. It tells us that if the hemoglobin is saturated at 98%, it tells you all there was for everything else is 2%. And so the maximum amount of carbon monoxide would be 2%. It tells you the maximum amount of carboxyhemoglobin. That was what was mentioned yesterday. The maximum amount is 2%. It doesn't even tell you that it is 2%. It could be something else. But 2% of carboxyhemoglobin is within the normal range. You and I have levels of carboxyhemoglobin of somewhere between 0 and 3.
I'll let you guys know. Mistrial means
And
the trial.
so in
will
other
go-
words, as to the statement that his carboxyhemoglobin could have increased by 10 to 18%, in your view, that's not possible.
It's simply wrong.
And it was at most 2%,
At most 2%.
normal.
Which is normal.
So they're saying a slide was wrong. It couldn't have been right because the
Uh,
most it
new
could have been was
subject.
2%.
To discuss with you.
Yeah, get off that quickly.
You might recall, if you were listening to the testimony, my discussing with Dr. Fowler the hypopharynx.
Yes, I remember.
And you might recall I spent some time asking him about what research he had done on the potential for pressure on the back to narrow the hypopharynx.
Yeah, I recall that.
Do you recall him saying he had canvassed the literature and he could not find anything?
I'm sorry.
Do you recall him saying he had reviewed the research and that he could not find anything?
Yes, I recall him saying that.
Are you able to enlighten or give any information to the jury on the nature of the research on the hypopharynx and how it narrows with compression in the prone position?
Yeah. So, the research on this, which is extensive, is really in
We're only
the
gonna go back
scientific
after they
literature, it's in the
testify. We're gonna go back and check
physiological
that out.
literature. And that is applied over to clinical medicine. So the type of studies that are done are not really done in terms of ordinary clinical research. It's much more a physiological, much more scientific of how the body works. And there's about probably at least a dozen, maybe 20 studies that show the relationship between how that if you lower the size of the lungs, you must get a decrease in the size of the hypopharynx. All of the studies show that.
And then are there studies then that look at whether the pressure on the neck narrows the hypopharynx?
No, because when we do research, we try and do research on studies that might be puzzling, that you would be kind of expecting a bit of a surprise. If you think about sticking your fingers into your neck, you know you're going to narrow the hypopharynx. That's not kind of research that somebody is going to want to do. It's so common sense that you would know that that's going to happen. You can do it on yourself if you want. And as soon as you put pressure here, you can immediately sense that your upper airway is narrowing.
Dr. Tobin, that is all we wanted to clarify with you this morning.
Okay.
Sure. Let's do a stretch break in place.
All right, I'm gonna go. Oh no, he's gonna about to get questioned by the defense. I want to go back to hear that part again. What's going on? Why they turned off the audio. I don't know what they're doing. Tobin looks nervous. He looks nervous. We can't hear anything. All right, so just so everybody understands what happened, they weren't supposed to be able to mention the test that they didn't turn over to the defense. It seems like he mentioned the test, and the judge said, if you mention the test, we get a mistrial. So it seems like he mentioned the test. I'm not sure. I'm not positive, but it seems like he mentioned the test. That's why they had the objection. That's why the objection was sustained. Mistrial means the trial would be over, and possibly jeopardy would be attached, would mean they wouldn't be able to retry Chauvin for this. So I think they're trying to work that out now. That's what it is. I'm trying to give me a second. So I don't know what they're working out now, but that was like ridiculously stupid. Oh yeah, no, we're gonna look at it again. I'm on my phone about to listen to it again right now. Give me a second, because I don't want to miss his testimony. I don't know what they're doing right now, but I want to keep this up. Wow. And those are like 2 quick questions too. I was like, all right, I don't even know why you bring them back for that. Kind of ridiculous. All right. So I just so everybody understands, I rechecked it. I'm not sure if it's the test that they didn't allow in. He said it's the arterial blood glass. So I have to go back to now listen to what they didn't allow in, because I don't know if that was the test. But they sustained that objection. Maybe they just said, well, the jury won't know what the hell arterial blood glass, test is. And then they went to another test. So I'm not sure. But why is he not talking? Why am I not hearing anything? Hold on. Let me see. I'm not hearing anything from the feed. They're not talking, right? I'm not hearing anything on any feed. Let me check another feed just in case. Oh, no, they're not talking. They're doing a sidebar. So I'm just honestly, I'm keeping it here because I want to do this, but I want to go back to, are we talking about, can somebody check, if anybody, you guys can check too, whether it was the arterial blood glass test. That's what there was not allowed to be in the sidebar. Said Nelson could reserve the motion for mistrial until after questioning. Okay.
There's the jury. We're going to actually have a recess now until 1:45. So we'll reconvene at that time.
All right. So we're going to know now. All right. So something happened. Something happened. Okay. Whew. So we got to go back. What the hell is going on? All right. Arterial. So let's go. So let's just do this play by play. Let me go back to to this. So this is the part that's in contention. Let me go back. Okay, so he gets some.
18%.
Correct. Yeah, I saw that.
Would you first just tell us right off the bat, do you agree with that proposition that's highlighted there?
No, I do not.
Now, would you tell us what carboxyhemoglobin is?
Yeah. Carboxyhemoglobin is when the carbon monoxide combines with the protein.
So this is right before the objection.
Hemoglobin, and so it's the combination of the carbon.
Why is carboxyhemoglobin, again, important?
It's important because when it displaces oxygen on the hemoglobin, you don't want the carboxy in it, it takes it over.
I'm trying to find
Do
that.
you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18% is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on
I'm reading the
the
side chat.
arterial blood gas that was obtained when Mr. Floyd was in Henneman County.
So that's the objection,
Please, sidebar.
and that's the sidebar. All right, so now let me read the side chat because people are saying read the side chat. So that's the test, but I'm not sure if that's the test that they couldn't mention. So let's go back to the side chat. I'm looking at the side chat. Looking at the side chat. Nate the lawyer, read the side chat. I'm reading the side chat. I see nothing. I see nothing. Maybe you got to put it again. So is that the test they couldn't mention? Gas obtained like a test. No. All right. Audio is 10 out of 10. The audio is 10 out of 10. Terrible right now. Yeah. I was checking. The only test, the CO2, the only test for the CO2 was excluded. All right. Maybe. So why would they strike that then? I don't know. You guys said the audio is bad? Sorry, let me go back to the live feed.
I think the objection.
All right, so that's the live feed. I don't know. Was that the test that was excluded? The arterial blood gas test. I don't know. See, I'm just not. Nate the lawyer, only the test for the CO2. So why would they object? And why would it be sustained? I got to go back. I have to see. I got to go back and look at it all because it just doesn't make sense. Yeah, I think that was the test too. You know what? Let me go back here. Let me see if I can find it. Let me see if I can find it. You guys got to bear with me because I'm going to go back and try to see if I can find this thing. I want to go back to when they were talking about what he could and could not say. Let's go back all the way to the beginning. Of it. Arterial blood gas.
Go to the ER. Physicians would be the ones that they request to see the values on. So, but we did not contact him. It was the other way around.
And we're talking about carboxyhemoglobin readings. Is there also anything as part of that specifically about carbon monoxide concentrations?
Yeah, the carboxyhemoglobin reading would show the carbon monoxide concentrations, Your Honor, and the record, which had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler.
I want to hear that. What's the name of the test?
And on the slide that Mr. notes, carboxyhemoglobin could have increased by 10 to 18%.
Okay.
Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of content in his blood. Now, the concept of carbon monoxide discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally, but not a specific reference to the carboxyhemoglobin content.
I'm just going to go to the live feed because I don't want to be behind on the live feed. I'm going to check on my phone, but maybe I'm confusing the two tests. Maybe I don't know. But there was as soon as he said it, there was an objection. So maybe I'm wrong. Nate, the lawyer, I think the blood tunnel test is a bunch. If the prosecution doesn't answer the blood glucose, I don't know, maybe. But they can mention the blood panel. Okay, that makes sense. We'll see, because there was an objection and now they're stopped. Like he's not even crossing him now. So I don't know. Nate, the lawyer, you're confusing carbon monoxide with carbon dioxide. You're probably right. Maybe you're right. Oh, no. We're talking about specific tests. I'm not a doctor, so I don't know the different names of the test. But I know one of the tests we were specifically not able to mention. So I was trying to see if that was the test that was excluded by the judge, but I just don't know. I just don't know. We'll go back. B. Pratt says it was. Well, I don't want to go back and look for it now, because if I go back and look for it now here on the stream, it's going to be it was going to take me a while to get to it. I don't want to get If you're confused, you're not alone. This court seems to be gasped at the moment. Something happened. So, again, I just want to make it very clear. I could totally be wrong, right? Because I don't know what the name of the test. I could, they could be talking about carbon dioxide. Something else could have happened for that objection. I was just assuming, because as soon as he mentioned the test, the test when it came to carbon monoxide, it was objection, and that objection was sustained. So double monitor. yeah, I need to get a double monitor. Yeah, I have a double computer though. Where is this? Nate? I did, but I don't want to rewind it and then be be lost. Don't catch up. So if anybody else can find it, if anybody else can just go back and just listen for it and just let me know. And just let me know, because they say the name of the test, and if the name of the test they say is excluded is the same name of the test they say that he says at that moment, then we have our answer. But I can't verify it now. But I believe you guys. There's a whole bunch of people in here. I'll look on my phone too. Now I even forgot the name of the new test. They wouldn't shut down a trial like this if there was permissible evidence. That's true. That's what I'm assuming. Okay. The judge did not name. I found that the judge did not name the test. Okay. All right. So some people saying it's not. Some people. All right. Thank you. Changing things. He's looking at it for us just to make sure. CRISPR, my brother. CRISPR, Nathan Lawyer excluded. CO2 arterial blood glass admitted. CO2 arterial blood glass. CO arterial blood glass excluded. Okay. All right. That makes sense. Thanks, CRISPR. So let's see. Yeah, but that's exactly. Well, hold on. But that's what they were talking about, right? Carbon monoxide. I don't know. This is why I'm a lawyer, not a doctor. So all right. So everyone understands why this is important, right? Because they can't. They can't mention. There's one test they can't mention. One test they can. And it seems like the doctor may have mentioned the test that they can't mention versus the test they can. So we'll see. All right, carbon hemoglobin was the value of ABS test. The value is prohibited. Yes. I think the sidebar was due to confusion. He was very close to blowing it. Okay. All right. You see how there's a razor thin edge, right? To a mistrial. Like, oh my God. But why would you stop why would you just cut the trial like this? Right before cross, after this guy's testified. Something's going on. All right. No, he didn't. All right. Okay. No, he did not mention the excluded test. Okay. Maybe that makes it. So damn it, Nate. You're a lawyer, not a doctor. That's true. All right. So Fiona, a couple of people said he has. I got to go back and check it myself, though. Changing things is checking it out, too. I think they're saying, I think they're trying to find a way to remedy the damage. But I'm not even sure if there was damage. Only thing we do know, the doctor mentioned a test, objection, and that was sustained. So the one thing is that it doesn't seem like that was the test that they were allowed to mention. Why would they sustain the objection, right? So I think we have, I think there's something, right? My only evidence is that they sustained the objection. So, Nate the lawyer, if he said because the CO2 arterial blood gas, it would be a mistrial. The defense assumed he said enough. The judge disagreed. Yeah, it looks like. Ooh. Judge might have to take a dump. Oh, I don't know. I think they're in chambers because the jury's out there, so they can't just have it right there. They're probably in chambers. Nate, the judge might be making phone calls. The place is going to riot if it's a mistrial. It would. But you can't surprise the defense after they close with new evidence that you've had for over 2 months. It's not fair. Not fair to anybody. So yeah. He did mention the test. I based it on the arterial blood gas that was obtained with Mr. Floyd. That's what he said. That's what he said. Nate, the lawyer, adjourned until 1:45 for lunch. Jobs. Oof. Nate, the lawyer, I think he saved it with focusing on the results drawn from the blood center. Maybe. I'm making sure I'm live because he's got to tell us something, right? This is crazy. Mr. Trial, Nate, the lawyer, the judge, lab tests were not allowed. Discuss, but did talk about CO. We're all waiting here, this sounds crazy. Let me share. All right. So here is it. I don't know if you guys can hear this.
Do you have an opinion to a reasonable degree of medical certainty as to whether this statement that Mr. Floyd's carboxyhemoglobin could have increased by 10 to 18%?
So we're talking about carboxyhemoglobin, right?
Is reliable?
No, I believe it is not reliable.
Would you tell the ladies and gentlemen why that statement is not reliable?
I base it on the arterial blood gas that was obtained when Mr. Floyd was in Hennepin County.
That's the objection. So CRISPR, it sounds like that's the no, right? Is CRISPR still it? CRISPR. Arterial blood gas, and they're talking about carbon monoxide. You said that was the one that was excluded, CRISPR. Is that the one we're talking about? That was the one that seems CRISPR. That's my man CRISPR-Cas9. You said that was the one that was excluded. Is that the one that was excluded? CRISPR is my CRISPR and Fiona, for those who don't know who are in the side chat. Those are my medical people. Those are my medical people. So if you got a medical question, those are the experts. Those are my in-trial experts. These people are the ones who know the science. If I say X and they say Y, believe them. Don't believe me. CRISPR, Nate the lawyer, right? If he said CO, but he didn't. Okay. All right. So now we got to sing. Intrigue, right? Intrigue. This is crazy. Did they blow it? What do you guys think? If this happens, though, this would be the stupidest thing ever, right? This would be like the worst. I'm talking about like careers will end on some stupidity like this. Wow. I don't know. Nate, the lawyer, when questioning continues, explains that oxygen levels led him to conclude that CO levels are below. Yeah, I remember that. I don't know. Was there any damage done? How, here we go. Let's listen. And I could be totally wrong. We could be misreading it. So I'm just going on what we heard.
Still under oath, Dr. Tobin. Okay.
All right. So let's say everything's good. Here we go.
Just have a few follow-up questions for you, Dr. Tobin. Thank you. In terms of the carbon monoxide testing that you referenced, you would agree with me that the most common technology available in hospital laboratories for analyzing the blood is the multiple wavelength spectrophotometer, also known as the co-oximeter, correct?
Right.
Yeah. Now, in terms of your testimony relevant to the research, you referenced that there were 12 to 20 studies, and correct me if I'm wrong,
Yep.
that an increase in pressure on the lungs would increase the narrowing of the hypopharynx.
Not quite.
Okay, can you just say it again?
Yeah, I mean, it is that if you decrease the size of the lungs, that you will get narrowing of the hypopharynx.
And that research would be in physiological journals?
It would be in physiological journals. There's some journals that will be a blend of physiology plus clinical. It will be, but it's primarily going to be in physiological oriented journals.
And those physiological oriented journals would be included within the general search for medical literature.
I mean, if you go into PubMed, it would be included in PubMed, yes.
And you have not produced any of those 12 to 20 articles for the state or I to review.
I mean, I listed several articles in my report of January the 27th. There's several articles in that. I can tell you them if you want it.
Specifically that stand for that proposition.
Regarding the relationship between lung volume and the hypopharynx.
I have no further questions.
Oh, Your Honor.
All right. That's it for rebuttal.
Thank you, Doctor. You may step down and you are excused.
Thank you
That's
very
it.
much.
That's all for witnesses. That was one exciting witness for 5 seconds. All right, so it seems like there was not an issue.
Yeah. Mr. Blackwell.
Your Honor, the state of Minnesota rest.
Mr. Nelson, anything further? All right, members of the jury, the evidence is now complete for this case.
So that's it. On to
Next
the
step for
jury.
you is to listen to closing arguments and then retire for deliberations. That'll occur on Monday.
So Monday,
The
closing
attorneys and I will still be working. We have a few administrative matters and legal matters to take care of. Most importantly, going over the law that I will give you in my instructions. And that takes quite a while. And so we are not going to change our schedule. We're not going to close tomorrow. We're going to close on Monday. And so with that,
Tomorrow's off.
remember,
They're
you
off
will
tomorrow.
be sequestered. We have some of your questions and we're going to try and answer as many of those as we can. I think the one thing that you need to know today as you leave is how much do I pack? If I were you, I would plan for long and hope for short. Basically, it's up to the jury how long you deliberate, how long you need to come to a unanimous decision on any count. And so because that's entirely up to you, whether it's an hour or a week, it's entirely within your province. So that's how I would do it if I were you. We'll also give you some information,
Okay. Thanks, David.
probably Monday as you retire as to other questions that don't require your immediate attention. And we will also be probably giving you some hints as far as technology. We will be operating under the rules that are currently in place regarding audio and video evidence. And that is specifically that you will be provided with a laptop computer that has all the audio and video, in fact, pretty much all the exhibits in this case, on the computer and with a large monitor to play them. You will not have to come back into the courtroom each time you want to look at the audio or video, which is the old rules, which involves a lot of back and forth. We're not going to do that.
A weekend.
We're just going to give you that computer with the arrangements so that you can view it as you deem appropriate as part of your deliberations. So with that, I wish you a good long weekend, and we will see you Monday morning. We will convene at 9 a.m. for closing arguments and final instructions. Thank you so much.
Bye-bye,
All right, for the
jury.
jury.
So the prosecution almost blew their case. Oh my God. They almost blew their case. No mistrial. I don't think he got enough out. I just don't think he got enough out. I think they got close, but it wasn't enough where like, what are they talking about? All right. So it's to the jury, guys. Let's just call it what it is. That's it. Right. The lawyers are going to handle this last second thing. I'm just damn curious.
We are still on the record outside
here
the
they
hearing
go.
of the jury.
So the jury's gone.
With regard to the charge conference, I think the parties had agreed that we could do this informally off the record in chambers. Is that correct from the state?
Nelson objected too fast.
Mr. Nelson. Okay, Mr. Chauvin, you have the right to be present at all phases of the trial. That would actually include the charge conference. But basically, you'd be watching the lawyers and I wordsmithing the instructions, and I think you already have a copy. You want to be present for that, or are you willing to waive your presence? All right. We'd probably put any discussions on the record just to memorialize what we've decided. And you're willing for us to do that without you present, is that correct? Any requests that have already been made by the attorneys as far as proposed instructions, that constitutes a motion for me to give those instructions to the jury. So there's no need for your lawyer to object to anything because if I don't give anything your lawyer says, that's essentially denying the motion for that proposed instruction. The same thing is true for the state. Any of their proposed instructions memorialize their request. There's no need for an additional motion objecting to whatever I decide is the final instructions. So with that, also, we have all been talking about the appropriate way to deal with questions from the jury. Occasionally, jury questions will arise. I think our preference is that we not move the jury around if we can avoid it, and also that we not have people coming and going from the government center. Since you will not be required to stay here at the government center while the deliberation is occurring. Accordingly, our plan is that we do any questions by Zoom. If you recall earlier when I brought back several of the jurors who had been selected to talk about the possible effect that Minneapolis city settlement had, that's how we would do jury questions. In other words, they would be able to see us, we would be able to see them. And when I say we, I mean the parties, yourself. But the jury, because they're anonymous, would not be broadcast to the outside world. And that would be our plan for how to answer questions. Any questions that come to me from the jury, the first step is to talk to all the lawyers, get their input on how I should answer it. Very often it is rereading certain instructions, but in any case, I will talk to all the lawyers, and after talking with them, formulate what my answer is going to be. That will be on the record, but it will be by Zoom. Are you fine with that arrangement since you don't have to be here? We would want you to be part of the Zoom, so you've got to be subject to getting in front of a computer, basically. Are you fine with that? All right. Anything else as far as before we go into the charge conference?
Not from the state, Your Honor.
Okay.
No, Your Honor.
All right. Then we are off the record until Monday at
All right, so that's it.
9 a.m. Thank you.
That is it. The game is over. So let me read this. I worked at CVICU and have drawn ABGs. They already used ABG results. If he said the carbiox hemoglobin, I don't know how to say that word, level obtained through the ABG led me to believe X, he would be toast. So David Rucker has definitively answered that question. I think it was objected to early enough where you didn't have a problem. There was another super chat that came in. Appreciate you doing these commentary streams. At the point that YouTube is making hard to use public content. Your insight and chat adds value. Thank you so much. So if you guys want to see the proposed jury instructions for the defense, stay tuned. I'm going to pull them up right now so we can see. This was interesting. You know, you almost had a mistrial here, but I'm just going to pull up the proposed jury instructions that the defense has submitted already so we can see what they want to get through. We're just going to do a quick skim, but I want you guys to see that, you know, since you're here and we're talking about proposed jury instructions, let's just look at what the defense has already put through. If you guys want to do it, if you guys, some of you guys don't want to stay for that, that's more than fine. I just like to be thorough when I do these streams, especially since we're talking about jury instructions. So let me pull this up. Let me copy this. Give me 1 second. Let me close this stream down. All right, so here we go. So we're about to look at the proposed jury instructions from the defense. Give me 1 second. All right, so here are, let me screen share this so we can see the proposed jury instructions from the defense. So this guy, he's doing an excellent job. Legal Insurrection, you should definitely check out this site. He's put everything together and, you know, he's done all the heavy lifting. So, you know, I want to say thank you to this guy. He's making it. So this is Eric Nelson. This is the defendant's proposed jury instruction. So we're seeing it Move this over, expand this. So make sure you guys can see it. This is the defense proposed jury instructions, even signed by Nelson. So you are looking at what the defense has turned in. So just so everybody understands what I'm talking about and what we're about to go into. Each side gives gives jury instructions, right? And those jury instructions are saying, this is what we want the jury to be instructed on. This is how we want the jury to be instructed. And the judge takes both those and then creates jury instructions and read them to it. So first, I want to give Robert Gruler credit for these because he pointed me to this website. So, and this person's already, this person, Legal Insurrections, already got everything together. So that's fantastic. And I was actually going to look for the state's website, but this guy's already done the hard work. So, Legal Insurrection, amazing stuff. So let's look at the jury instructions. So we can all see what the charges are, what their proposed charges are. So let me go here so we can look through them. And here he is. So this is Derek Chauvin, Eric Nelson. So this is his bar number there. So they want to instruct the jury the duties of the juror, presumption of innocence. These are all, and they get the site from where these are. Proof beyond reasonable doubt. Proof beyond reasonable doubt is such proof as an ordinary prudent man and woman would act upon in their most important affairs. So remember, if you're a juror, this is the standard that you have to look to. A reasonable doubt is a doubt based upon reason and common sense. It does not mean beyond all possibility of doubt, or a doubt based upon speculation or irrelevant details. If a jury views the evidence, in this case, as reasonably permitting either of two conclusions, one of innocence, the other of guilt, the jury must, of course, adopt the conclusion of innocence. So if the jury views the evidence, in this case, as reasonably pertaining to either of the two conclusions, one of innocence and one of guilt, so in other words, you got a 50-50, the jury must adopt the conclusion of innocence. So, and he puts a case site here. So they're talking about direct and circumstantial evidence, rulings, evidence. I really want to get to the charges here because I don't want to get you note taken by the juror, evaluation of testimonies. Let's get to, they may have expert witness, impeachment, testimony of occurrences, authority to arrest. All right, so here we go. This is where they give to authority to arrest. So in other words, he's a police officer. So they have the authority to arrest, passing a possession of counterfeit bills. I don't know why this is in here. This is saying that, did Floyd commit the crime? So I don't know why they would put this in here. But so this is what Floyd would be convicted of, would be guilty of, passing or possessing a fake counterfeit bill. So I'm not sure why he would have that in there as a jury instruction. Felony murder in the second degree under Minnesota law. So this is just the felony murder statute, committing any underlying felony. He gives the elements. One of the elements is first, the death of George Floyd must be proven. The second is defendant caused the death. This means substantial cause to be a substantial causal factor in the cause of the death. So this is something that I think we all know. Third, the defendant's time of death. So this, in other words, this is saying that it all has to happen in one continuous transaction, right? You can't assault him the day and he dies a year from now, something like that. And here's the assault in the third degree. This is the underlying felony, assault in the third degree defined. And then they give the elements for assault in the third degree. So everybody understands, for anybody who's still watching, even though they're charging murder in the second degree, the underlying felony is assault in the third degree. So they're giving the jurors the law and saying, if you find him guilty of assault in the third degree, then you have second degree murder. So that's what we got here. I'm just going to run through the rest of the jury instructions. Is your second degree manslaughter. Here's his proposed jury instructions on that. Manslaughter causation. So it's all here. What I'm going to do so you guys don't have to do this, I'm going to put this in the side chat. So that's the link to the jury instructions. You guys can go and check them out for yourself. But I just want to make it very clear. So if he is guilty of assault, then I think you have your felony murder. I think they include the counterfeit stuff to emphasize Floyd was not just jaywalking. It's it was a serious situation. Possibly. But I don't know if that's going to make it to the jury instructions, because the jury don't have to find that Floyd committed a crime, right? They have to find that Chauvin committed a crime or not. Or maybe maybe putting that in there to show that Chauvin was authorized to make the arrest because of the crime of that. So murder is the murder 3 needs to be added. Murder 3 is in here. But again, I put the link in the chat, so you guys go and check out the jury instructions. There's also the law there about self-defense and all that other stuff, so you guys can check it out. So this is actually good. It's good to read, so you guys will know what the jury is going to get, or something similar to what the jury is going to get. And the prosecution's jury instructions are also there too, so you guys can get a little bit more familiar with that. So remember, tomorrow we probably have no court. Monday we have closing, and Tuesday, and after closing on Monday, the jury is going to have it, and we should have our answer by the end of the week. So with that all said, I hope you guys enjoyed this stream. We'll come back on Monday. We'll do this again to look at the closings, and then we'll probably go through it after closings. We'll listen to the jury instructions. Then we'll have our little say at it to see whether this is good or not. Last question before I get out of here. I got to agree with Barnes. You can't call assault the underlying felony. Any murder would be, of course. Yeah. No, we all agree with that. Accidental death. No, Charlie, we agree with that, right? Every lawyer who you told is going to agree with that. It's just the law in Minnesota. I can't change the law in Minnesota. The law in Minnesota says you can do it. You're looking at the jury instructions. I understand you don't like it, but this is the defense's jury instructions about that. They're saying that they got to prove murder, the second degree. So, it just is what it is. Minnesota needs to change their law. Thank you, Jamie, for the $5. And I hope this was helpful. I hope you've learned something today. And like always, don't forget, like, share, subscribe if you like what you heard and if you enjoyed what you saw. My name is Nate the Lawyer, and I am going to see you next time. Don't forget, be kind to each other.